So we're going to talk about closing arguments here, as you might expect, given that we're at the closing portion of the day. So, Kenneth, when do you start composing your closing argument?
I literally start composing my closing, at least not in writing, but in my thoughts when I get the case. As soon as you're starting to get discovery, you're already thinking about the end of the case. And that's what I teach all of the younger attorneys when I'm mentoring them. Should be going to the pattern jury instructions in whatever jurisdiction you're in. Know exactly what are the elements of the claim and the elements of the defenses, and that is how you should guide your entire case from the beginning.
And does it influence your discovery choices then, your depositions, et cetera?
Absolutely. I mean, if you don't know what you need to prove or disprove, you're going to be unable to do so. So you need to acquire the documents that you need. If it was a case like this, one of the jurors mentioned something about intellectual property. If that is an element of this claim, you would want to know that, and you would want to bring that out through your discovery and your document demands.
So we heard earlier this rather alarming statistic that some 80 to 85% of cases are won in the open. So you do an opening, you do all this stuff with the evidence, the witnesses, and yet you're trying to move 15 or 20%, or you're trying to be in that 15 or 20% perhaps that can win the case on a close. So knowing that, how does it affect your strategies for the close?
I mean, that is a really scary statistic. It is a frightening statistic, particularly if you're on the defense side, like I am. The jurors are essentially, if that statistic is accurate, and I have no reason to doubt that it is, are going to be making their decision in the first hour of the trial. And they're going to ignore all of the evidence, which is precisely what they are told not to do. The judge will instruct them to not make any decisions until the end of the case. It is telling me that, and where I practice, where you have an opportunity to speak to jurors, and it's a surprise to most attorneys and industry people in other jurisdictions, but in New York, your jury selection is unsupervised, which is why attorneys know these things, and you try to try your case in front of the jury in jury selection, because you might lose before you're even having an opening statement. So I think that it's really critical to stay true to your personality, not try to be somebody that you're not, and don't oversell, and be credible to try to engage the jurors and make contact with them and communicate with them.
Yeah, for people that aren't familiar with it and maybe not familiar with New York jurisprudence, why don't you explain that last comment that you made a little bit more, the way it works in New York and the fact that you basically do openings during voir dire and et cetera.
I've tried cases in multiple jurisdictions, some of which I'm not admitted when I've been asked to get admitted pro hoc to try cases for carriers in some other jurisdictions. New York is the only jurisdiction that I am aware of where so much happens that is truly unsupervised by the court. We have conferences where law clerks are conducting the conferences. We have law clerks making decisions on motions, effectively making the decisions, and the judge signs off on an order. In jury selection, it's been different since COVID, because of the restrictions, and there have been more restrictions in New York than probably most other places. There are many fewer trials, and when those trials are going forward, they're pre-assigning you to judges, and you're actually selecting jurors in the courtroom. So judges are often there now. But historically, I've been trying cases for 32 years, and I've only had a handful of cases where the judge was actually present during jury selection. So the lawyers it's a free-for-all, and attorneys will go as far as their adversary will let them, and you can engage a judge to get a ruling if you need to, but that is it's truly a mysterious way of trying cases.
Yeah, it was a surprise to me the first time I was picking a jury in New York, and do an opening was basically the instruction. So back to talking about our closes, what are some of the strategies that you employ when you're crafting a closing argument?
I think that there should be some repetitions. There's a lot of studies that talk about when you repeat certain things. Now, you don't want to bore the jury and you don't want to anger the judge, but when you make a statement or a comment multiple times, the jurors remember it. You're setting it in their mind. So Jerry did this, if you noticed. He used the same words in his opening as he did in his closing. He was prepared for his closing before they started the trial.
Yeah, I'm going to have a question about that. This is very loud, sorry.
And a number of the attorneys asked certain questions and they highlighted certain words that they wanted, and they used them multiple times. And that is an excellent strategy. Demonstrative evidence, if you're able to use it during your summation, is critical. I had a case where, give a little prop out to Magna here, that I had them as my trial tech on a case in New Jersey, and we had many, many hours of surveillance. And I spent the night with one of Magna's techs the night before summations, and he put together a very brief version of clips directly from the surveillance, and I narrated it during my summation, and that just killed the plaintiff's case. It was the end of the case for the plaintiff. So having your evidence, being strategical, using your time efficiently, those are very key points.
Judge Medina, any particular insight into, one, what do you think works for closing statements? But two, did you have any particular rules? Did you allow demonstratives? Just anything germane to that discussion?
Generally, I would allow whatever the lawyers could agree to, and that generally worked pretty well in Texas. But what you said here about starting with the pattern jury charge, I think is so significant. Know what the charge is going to be, and that's how you prepare your case from the very beginning. But closing arguments, the lawyers would sometime ask, well, how much time do I have, Your Honor? My response would be, speak at your own peril. You know, you can tell when the jury's tired and when they don't want to hear anymore, so pay attention to that, because if it's a long trial, they're ready to get out of here and make a decision and go home.
To your point, Your Honor, in familiarizing yourself with the pattern jury instructions, I find it's very critical to use words during your trial, during your opening, during your examination of the witnesses, your crosses, that are going to be the same ones as the judge is going to charge the jury at the end of the case. Because then the judge is basically going to affirm what you've been telling the jury through the entire trial. And it gives you more credibility. I always think it's very important every time I try a case, I'm trying it as if I'm the party, because if the jury doesn't believe in the lawyer and what the lawyer is saying, you have no chance of winning the case. They could love your client, but if they don't believe what you're selling, you probably won't win the case.
And to bolster that last point, we had a case, a trial once, where we did some jury research, same kind of things. I'm smiling because I think sound bites matter and repetition matters. And in any event, we were, suffice to say, our theory of the case and the story we were telling is that we were consistent. We were consistent with the law, we were consistent with the contract language, consistent. So starting in the opening, we used that word consistency and even worked it into some objections. And about 3/4 of the way through the trial, the opposing counsel made some sort of objection, and the judge said, "Aren't you being inconsistent?" And I thought, we got him, and we did. We got a 0 verdict. So can't echo that enough. I think it really matters, that repetition, but also picking up keywords that, for jurors, they're not used to being in a courtroom every day like we are. And I think there's I like to think, still some magic around the process. Sometimes you walk into a federal court and it's the whole, the big deal. It's a beautiful building. And, you got to transport yourself back a little bit to when you first walked in there as a law student or as a lawyer. I know the way I felt, and I think a lot of jurors feel that. They're part of something that's bigger than they are. And you have to play to that, too. They do want to see some drama. They want to do their job and do it well, and you got to give them the tools to be able to do that.
Another comment, just as a general rule in the courtroom, and I know that the judges commented on it today about being respectful to the court. The judge is always right. Whether the judge is correct or incorrect on the law, whether you agree or disagree, you treat the judge with respect, and the judge is right. Because the jury they all believe that every ruling the court is going to make is going to be correct, unless it's just so one-sided where it's obvious.
Right. And, and hopefully that you don't experience that, but certainly we've, as trial lawyers, have sometime felt that maybe the judge is ruling one way and shouldn't be. But hopefully that's very, very rare, because truly a judge should be out of the way Don't let a judge interfere with your case. Get all your pretrial motions done, and then put on your case. There was, I think Michael, when I made some objections against him, said, "Thank you, Your Honor," and he moved along. I think that's pretty effective because it tells a jury, maybe he was right, I'm not sure. He's being respectful to the judge, but the judge is not going to interfere with the case. I'm going to try my case and go forward. So I thought that was effective.
And there's a way to do it to preserve your record, but still be respected at the same time, right? So
Absolutely. And if you need to preserve your record, if you think that the judge is going to not be receptive to it, do it after the jurors after they leave the room. So you can create your record, make your record, but you're not doing it in their presence so that they don't see you arguing with the judge.
So now wear your defense hat here, because this is a hot topic, I think, generally speaking, and when we do some mocks, it's still a hot topic, and I'm not sure where I sit on it. But the idea of a defendant suggesting a number. So you go for the zero, or do you come in with something else to give the jury something else to think about as opposed to a straight zero?
Okay. I have changed my strategy on this, but to me, this is a black and white thing. Unless there is a very compelling reason not to suggest a number, and that sometimes happens. If you have a case it's you're just on liability, damages really aren't the issue. I think that it is a big mistake not to give a number, so you should give a number. In virtually every mock trial I've ever had where we've talked to jurors, and I think you were there in Chicago where we had one, when jurors were questioned afterwards and a defense attorney didn't give a number, they asked, "Why did you give such a high number?" And the answer across the board was,
"No other choice.
We didn't have any other number." So the jurors are presuming that the attorney who's handling the case is familiar with that type of case. They're an expert in that field. And they're going to project it, they're going to make a number, make a demand that's reflective of what that case should be. And if you don't give an alternative number, the jury only has one number to think about. So
we got
I tend to lowball them. I give a number, and that's very disproportionately low, and suggest that the plaintiff is going to be outrageous, so that then their number is even more outrageous.
So we got to this a little bit earlier, but a good opening, you're going to promise the jurors certain things, right? You're going to tell them what you're going to do in the case, what you're going to show from the evidence, et cetera. So how much do you circle back to that in your close? Not just the words, but do you take a tally? I told you I was going to do this, this, and this, and I've done it. And we did see that strategy employed, I thought, very effectively.
I think that is a very important tool of trying cases, specifically with respect to summations. Your opening statement should not be argumentative. It shouldn't even be necessarily conversational. You're telling the jury what you're going to prove in your case. You're giving them a roadmap, and you're making promises to the jury of what you expect the evidence to show. And at your summation, you should come back to that and say, you've heard the evidence, I made these promises, and I fulfilled them.
So one final question. So throughout the course of a trial, no matter how hard you try, you're going to have some great points, and you're going to have some that didn't go so well. So how do you address weaknesses in your client's case during summation?
That's a tricky one. If it is an absolute killer, you might want to ignore it. If you know that your opponent is going to seize on it, which is likely the case if you're trying your case against competent counsel, then you should address it head on, not be afraid of it, and bring it up so that the plaintiff's counsel doesn't make a comment about why you're ignoring it. So it's better just to take it on, explain it, and then quickly move on.
Well, great. I really enjoyed that, and thank you again. Former competitor, so he had the guts to stand up here and do this when we were running chickens at him or whatever we were doing in 2016. I can't remember, but thank you so much.
Thank you very much.